what is the world, what is the high-level panel, and who am I? My name is Helena Kennedy. I'm Baroness Helena Kennedy. I'm a member of the House of Lords in the United Kingdom, and I'm also a lawyer. And I'm the director of the Institute of Human Rights for the International Bar Association. Now, the high-level panel of legal experts freedom, Lord Neuberger, who's with us, David Neuberger, who was the president of our Supreme Court. He convened this high-level panel at the request of the United Kingdom and Canadian governments, and they served as the co-chairs of the Media Freedom Coalition. They had come together seeing the great threats there are in our world to media freedom. And Lord Neuberger, taking on the chair, appointed as his deputy chair to the panel, the international lawyer, Amal Clooney, a very distinguished legal expert. The panel is composed of independent lawyers who have got great expertise in the field of international law and media freedom, and they're drawn from a number of jurisdictions around the world, east and west, north and south. Now, the role of the Institute of the International Bar Association, the Institute of Human Rights, which I'm the director of, is that we run the secretariat for this high-level panel. And we have done this from the outset, and we really do help to pull together the great work of the high-level panel. UNESCO administers the Global Media Defence Fund and the Multi-Partner Trust Fund with the goal of enhancing media protection and improving the access of journalists to specialised legal assistance. So UNESCO is the umbrella for a great project, which is to protect media freedom. Now, the Media Freedom Coalition, as I said, started off with two co-chairs, the United Kingdom and Canada. Their foreign secretaries kicked this off. But it now has a membership of 47 states committed to working together to advocate for media freedom and safety of journalists, and to hold to account those who harm journalists for doing their job. Now, the coalition continues to grow, and they put out a communique last November, and when they had their first ministerial meeting. And that communique indicated their commitment to take advice from the high-level panel and to draw upon the reports which are currently being produced by that expert panel of lawyers. It's clear from that communique that they really are committed to the protection of media freedom. So today you're going to hear about some of the panel's work and the panel's ongoing work that we intend doing going forward. And it's, of course, being set against a whole set of formidable challenges just now because of COVID, because of the ways in which populism has seen the spread of authoritarianism and authoritarian leaders. Let me introduce you to the chair of the high-level panel, the distinguished lawyer, Lord David Neuberger of Abbotsbury, who was the former president of the Supreme Court of the United Kingdom. Before that was the Master of the Rolls, and in the UK Court of Appeal. Lord Neuberger has sat on some of the most significant human rights and constitutional law cases in the United Kingdom, and he's a well-known arbitrator globally. So please, Lord Neuberger.
Thank you very much, Helena. When I was asked or encouraged to set up this very significant panel, I don't think anyone realized what was going to happen in the next 2 years. And in terms of the problems of populism and the excuse that COVID-19 pandemic has given to authoritarian governments, and even at times to some governments that are not naturally authoritarian, there is real cause for concern about freedom of expression, because in the end, journalist freedom, media freedom is not just about freedom for the benefit of media, freedom for the benefit of journalists, it's for the freedom of everybody. And freedom of expression is as fundamental a freedom as exists anywhere. And therefore, I like to think that the role of this panel is very timely, as well as being very important. I think I've been very fortunate in being able to recruit and encourage a number of very significant and informed people across the world into joining the panel and into writing material for us and representing the panel and what it stands for. And I always feel, as I do today, rather embarrassed looking round, for instance, at Jan here, Jan Yaginsu, who has written one of the reports, who, along with Amal Clooney and a number of other people, have done so much work to support our very important aims. Now, let me tell you a little bit about what we've done. We have already published 4 advisory reports. These are reports which make concrete recommendations in specific areas, because the whole of our approach has been, well, so far, I have rather gone against it by speaking in very high level terms. The whole of our approach has been aimed at being practical in terms of providing specific, granular, clear guidance as to what might be done and providing suggestions and advice. And when it comes to the 4 advisory reports, that is very much how we've approached matters. The first report is advising on promoting more effective investigations into abuses against journalists. It's been authored, as have all the reports, by a member of the panel, Nadeem Houri, the Executive Director of the Arab Reform Initiative, a human rights lawyer. And after a close analysis of the relevant facts and background in various countries across the world, it comes up with 3 recommendations to those who've signed the Global Pledge on Media Freedom and other key governments: strengthen investigations into attacks on journalists, address the issue of impunity and progress towards accountability. And this includes the creation of a standing international investigating task force. The second report is providing safe refuge for journalists at risk. That's been authored by Professor Jan Yaginsu, whom I mentioned briefly. He's a barrister and academic, and he'll be talking about it shortly, so I won't say more about it. The third advisory report is concerned with protecting and promoting press freedom by strengthening consular support to journalists at risk. It's written by Irwin Cotler, chair of the Raoul Wallenberg Center for Human Rights, who's a former Minister of Justice and Attorney General of Canada. Contains a number of recommendations, including that states should introduce emergency visas for journalists at risk and their immediate families. And if they're not prepared to do that, they should at least introduce an expedited process, and at any rate, the opportunity to apply for such visas urgently. It also suggests that journalists who are under threat or at risk should be within the definition of refugee for the purpose of the Refugee Convention. And a number of other points are raised too, including Interpol's reaction to red notices, which are sometimes used to catch journalists by tyrannical states. The fourth report is the use of targeted sanctions to protect journalists, written by Amal Clooney, who Helena has already mentioned. It contains an in-depth analysis of the existing systems for targeted sanctions in the United States, United Kingdom, Canada, and the EU. And it concludes with 11 recommendations aimed at implementing global human rights sanction regimes so that journalists are properly protected. And it includes recommendations that states should introduce or amend existing sanction regimes so they're global in scope and apply to the sort of abuses which we are concerned with, namely interfering with press freedom. In addition to these reports, we also provide what we term technical assistance. This consists of advice provided to states who've solicited it in relation to specific legislative reform. Catherine Anita will speak about the panel's work in reviewing and providing its input into the cybersecurity and data protection bill in Zimbabwe, to which she's done so much. The panel is also working with leading academic institutions and law firms across the world to provide advice on model elements for drafting and interpreting legislation in line with international human rights standards. This involves reviewing the laws that are most frequently used to target media freedom and studying their use in prosecutions across the world, reviewing existing standards and guidelines, and providing advice. And from June, we'll start publication of these international standards, beginning with a report written by Professor Park and Jan Yuginsu on internet shutdowns and access bans, which of course are an obvious way of interfering with press and everyone else's freedom. Then there'll be reports on sedition, defamation, lèse-majesté and similar laws, on misinformation and disinformation, on blasphemy and hate speech, on anti-terrorism and public order, and on espionage and official secrets, all of which on the face of it, or most of which on the face of it, do provide some sort of apparent justification for laws, but which are so easily used to muzzle press freedom illegitimately. On top of that, we will be engaging with the Media Freedom Coalition on the implementation of the recommendations in these reports. As I said at the beginning, all this needs to be set against the importance of the work today, which Helena has touched on and I touched on at the beginning of this talk. Anyone concerned with press freedom would not be comfortable about the history of the world in the past 2 years. Don't want to exaggerate, don't want to be alarmist. There are many bright spots, but there are many and increasing numbers of concern. Places that give rise for concern, laws that give rise for concern. And of course, the internet itself provides, just as it provides freedom of expression and assists freedom of expression, it is very easy to be misused to interfere with freedom of expression. So there is a real opportunity for states, particularly those who've joined the Media Freedom Coalition, to prove commitment to promote and protect media freedom. And the high-level panel is concerned with doing all it can and all its members can to support this. And I hope that I've given you some idea of what we've achieved so far and what we're hoping to achieve. Thank you very much, Helena.
Thank you very much, Lord Neuberger. I'm now going to welcome Jan Yuginsu, who's a member of the high-level panel, and as you've heard from Lord Neuberger, has been the producer of a very impressive report, and he'll speak to that in a moment. But I just want to tell you a bit about Jan, because he's not only on our panel, but I mean, he is absolutely a man of many parts. He has been consistently recognized as one of the United Kingdom's leading lawyers, practicing in civil liberties and human rights and constitutional matters, but also in international law. Jan has appeared in many, many cases representing journalists and covering media freedom in international courts of all of them, actually, and in tribunals. He is currently the International Counsel for that terrific and courageous journalist in the Philippines, Maria Ressa, and he's working on that case with Amal Clooney. He's also counsel for Wikimedia Foundation in a case that's happening at the European Court of Human Rights, and he teaches international law at Columbia Law School in New York and Georgetown Law in Washington, DC. He has very few spare minutes in his day. I'm going to pass you on to Jan.
Baroness Gundy, thank you very much indeed for that generous introduction. I suspect some of you in the virtual audience may recall that late last year, the high-level panel published its findings and its recommendations in relation to a key issue, the issue of providing safe refuge to journalists at risk. And back then, I certainly recall explaining why we as a panel had chosen to consider this issue, that every year schools of journalists are forced, yes, forced, to leave their countries to escape threats to their safety, that those are threats that have only arisen because those journalists have performed their duties as journalists to report the truth and to inform the public. And I also recall saying that we as a panel were not using the term forced lightly, because seeking safety abroad is all too often the only way for these journalists to avoid a number of very, very serious harms. Kidnapping, forced disappearance, arbitrary detention, violence, even assassination. But we also explained that that's only half the picture when it comes to risk. because for the scores of journalists able to seek safe refuge abroad, there were many, many more who could not. And more often than not, that's simply because they cannot move to safety in time, and that their inability to do so can and has come at an appalling cost to them, and often an appalling cost to their families. Now, our report as a panel documented a number of very chilling instances of journalists being subject to harassment, to torture, to death, sometimes tragically all three. And set against those detailed findings and conclusions and an in-depth analysis of potential lawful pathways to safety, the panel made, as Lord Neuberger intimated just a moment ago, a number of concrete recommendations at a granular level. Those recommendations were principally directed to the state members of the Media Freedom Coalition, a coalition of states that have pledged a commitment to promote and protect media freedom, and a coalition which, as Baroness Kennedy just recorded, is now 47 strong of states all around the world. And we were clear that none of the recommendations that we were putting forward were calling for wholesale changes to domestic systems of immigration or asylum. Each recommendation, each substantive recommendation, was instead providing a solution that simply gave effect to states' existing international legal obligations. And our headline recommendation was the introduction of a journalist-specific emergency visa. The visa wouldn't be dissimilar to the type of humanitarian visa offered currently by a scattering of states, including Germany, Switzerland, Norway, and the United States. And the emergency visa that we had in mind would be granted to those journalists who presented an arguable claim of exposure to a real risk of serious harm. And we provided detailed proposals in the body of the report as to how such a visa would operate in practice, how applications would be processed. We set out some of the steps that states introducing such a visa could take to ensure that the visa would be safe to apply for and effective for today's journalist at risk. And we consulted very widely before coming to these conclusions and recommendations. And all of the recommendations we've advanced were formally endorsed by Ms. Irene Khan, the UN Special Rapporteur on the promotion, protection, freedom of opinion and expression, by Professor Villarreal, the Special Rapporteur for freedom of expression for the Inter-American Commission on Human Rights, as well as the International Bar Association, and importantly, practically every major international non-governmental organization working to promote media freedom and the safety of journalists worldwide. We noted at the time that the report was published with a cautious optimism that the provision of safe refuge for journalists at risk was the first bullet point in the first ministerial communiqué that Baroness Kennedy referred to, published by the Media Freedom Coalition late last year. And we have purposely given the coalition members several months now to fully digest our findings and to fully digest our recommendations. Of course, in the intervening period of just a few months, the problem of journalistic safety has not gone away. In fact, it's gotten worse across the world. One need only read the analysis that accompanied Reporters Without Borders' World Press Freedom Index, which was published last week. One need only look at the findings of the report published yesterday by the partner organizations to the Council of Europe platform to promote the protection, journalism and the safety of journalists. 40% increase in reported breaches since 2019, cases engaging journalistic safety. Next month, we will start the panel's bilateral engagement with states on the specific issue of safe refuge. And I note that the session that follows this one in today's World Press Freedom Conference is hosted by the Media Freedom Coalition and is entitled "The Role of Governments in Protecting Media Freedom. What More Can the Media Freedom Coalition Do?" ? Well, As the independent legal panel of experts established to advise that body, to advise the coalition, we've offered the coalition with a mechanism for taking action that could have an enormous impact for good. And if each state offered a minimum of, for example, 50 emergency visas to journalists at risk, the coalition would be sending a clear and a very loud message of principle, whilst also saving scores of lives. So we offer the states in the coalition an opportunity, at little cost to them, to set an example through their actions. And what better way to do so by opening your doors to those who risk their lives to inform you and to inform us. Thank you very much. I'll hand back to Baroness Kennedy on that note.
Well, thank you, John. There is a challenge for any of you who are going to listen to the next session, that you might ask that question of whether the governments involved in the coalition might commit to establishing those visas that are so necessary to save the lives of journalists. But Jan, thank you very much for laying the ground of the work that you've been doing. Now, I want to introduce you to another of our high-level panel lawyers, Catherine Anite. Catherine is a human rights lawyer, and she was the founding director of the Freedom of Expression Hub in Uganda. She's on the board of the Media Legal Defense Initiative, and she is the global program director at Small Media. And she has done incredible work in senior positions in Uganda and regionally, advancing the right to freedom of expression and protecting the media through advocacy and challenging government restrictions on press freedom in domestic and regional courts. She's a Mandela Washington Fellow, and we're proud that she's part of our panel. Catherine, over to you. Can you unmute, please?
Well, the troubles of technology. Thank you so much, Helena, for that humble introduction. And I'm really glad to meet the other panelists again. It's been a whole year of not meeting, but there's a lot of great work that has been happening behind the scenes. So over the past 2 years since the panel was created, we've seen countries, enacting laws that restrict media freedom and suppress expression. But Zimbabwe has been undergoing a major media legal legislative reform phase. And so far, we have seen major changes in that legal framework, promoting freedom of expression, access to information, and media freedoms. So from the onset, this reform process really was aimed at repealing the previous framework of laws under the Access to Information and Protection of Privacy Act, which is commonly known as AIPA in Africa. Many people look at the AIPA of Zimbabwe as a very restrictive framework of laws that suppresses media freedom. But this reform process culminated into the drafting of 3 bills, which includes the Zimbabwe Media Commission Bill, the Data Protection Bill, and the Freedom of Information Bill, some of which have been passed. So the Zimbabwe Media Commission Bill is now an act, which was passed last year, and the Freedom of Information Bill is also an act. In August of 2019, the independent high-level panel was invited to provide input towards the Zimbabwe Media Commission Bill, and we drafted and shared with them an analysis, with comments and recommendations on how the bill should look like, focusing, of course, on international and regional standards and best practices on the right to freedom of expression, access to information, and the media. So briefly, that bill sought to enable the Media Commission to effectively protect the rights of freedom of expression and media in Zimbabwe, which are guaranteed under Article 61 of the Constitution. So I'll just point out one of the recommendations as the panel that we put out to Zimbabwe. We wanted, in the new law, a clarification on the appointments process and the composition procedure of the commissioners. rather than making, reference to constitutional provisions that were referred to in the memorandum of the bill. So here we looked at principles that establish independent and autonomous media regulators and further recommended for diversity and inclusion with emphasis on gender. And we're happy that in October of 2020, a diverse commission of 9 persons was appointed by President Mnangagwa. And this consists of highly knowledgeable media experts. But we're particularly happy with the number of women. The chair to that commission is a woman, Professor Ruby, and a personal friend of mine also, Mrs. Susan Makore. So we have lots of friends of the media who have constituted that commission. And we wish them the very best in conducting their duties. So we also recommended that the commission, rather than the minister of the ICT text lead in appointing the secretariat in the bill, we saw that the minister's hand was really all over the place, but we recommended that we have the commission take charge in appointing the secretariat. And I believe that this is reflected in the new Zimbabwe Media Commission Act of 2020. And we are hopeful that the commission will be influential in ensuring the promotion and defense of freedom of expression and the media. I know some of the commission members are listening in. Tabang, we're really proud of the work that you're doing to promote media freedom in Zimbabwe. So these are really among the many provisions for reform we discussed. And while we were invited to give our comments on the bill, on behalf of the panel, I took part in numerous discussions which with the ICT ministry, and those were led by the permanent secretary, Mr. Nick Mangwana, and the British Embassy FCDO. So we held engagements with MISA Zimbabwe and other organizations that promote media freedom in the country, and again highlighted areas that needed to be reformed. Our analysis was shared with members of parliament on the Media and ICT Committee. I believe that at that time we worked with a number of MPs, Honorable Prince Settlement and Kindness Paraza. And of course, would like to congratulate Mr. Kindness, Honorable Kindness. He was recently appointed as the ICT Minister. So we know that we have, people who would like to see media freedoms flourish in Zimbabwe, and we're happy to be working with that team. And upon his appointment, I sent him a message and joked that we now expect lots of internet shutdowns in Zimbabwe and restrictive laws. And he laughed and he's like, no, we're going to give Zimbabweans more internet. We're going to improve on the laws. So we're really happy to be a part of that process. So the second bill that we invited to give input in was the Cybersecurity and Data Protection Bill. This was last year in May, after it was gazetted. And this bill, was majorly, to increase cybersecurity in order to build confidence and trust in information technologies in Zimbabwe. As a panel, we believe that the proposed cybersecurity and data law is a positive step by Zimbabwe towards developing and protecting the information and communication technology structures and harnessing ICTs to advance rights of citizens. However, we did find that some provisions failed to meet the requisite standards on legitimate restrictions on those rights because some of them were vague and imprecise, and they were unnecessarily restrictive. They had harsh penalties for offenses for up to 20 years. So in summary, we did recommend for clarity on many of the provisions. We also recommended that the Cybersecurity Center and Data Protection Authority are independent bodies separate from the Postal and Telecommunication Regulatory Authority. We did recommend to include a provision allowing derogation for processing of data carried out for journalistic and academic or artistic expression, and clarity on exceptions arising out of grounds of national security, and clarity also on creation of the whistleblowing authority. And we particularly emphasized independence of that body if it's set up. So last year, again, we held meetings with civil society organizations facilitated by the FCDO, the British Embassy there, and partners to discuss the proposed bill and the recommendations. I was then invited on behalf of the panel, of the high-level panel, together with other experts from Privacy International and the Facebook policy manager of Sub-Saharan Africa to discuss the bill with members of parliament and the ICT ministry. So this discussion was coordinated by Mr. Zimbabwe, and we spent a whole morning really looking at each of the provisions of the bill. We assessed whether or not we need to reform them and why we should reform them. And we jointly really agreed on several provisions that needed change to conform to international standards and regional standards on media freedom, privacy, freedom of expression. And I believe that the bill is now before Parliament, and they will make reference to our engagement and discussion and the recommendations coming in from the different sections of the public to, including civil society, to enact a law that will guarantee the rights of Zimbabweans. Thank you very much.
Catherine, thank you. And for all of our audience, it really is important that there is that kind of technical assistance available from the high-level panel. So as well as creating reports, we have the great work that Catherine has done and that we will continue to do if any of the nations who are committed to media freedom seek assistance. But let me just also remind you before we move on that all these reports are available on the IBA website. So do, if you want to read into any of this more fully, access it that way. Now, in the autumn, we will be considering more closely systemic restrictions to the media. And a recent example of this is the application of the Foreign Agents Law in the Russian Federation, and it's being applied to media organizations and human rights defenders. And I wanted to just give you a little bit of background before I introduce you to the next stage of this webinar. Radio Free Europe and Radio Liberty is one of the few remaining news organizations operating in Russia that provides independent reporting in the Russian language on matters of public interest. Now, since 2017, they have been subject to administrative protocols from the Russian Ministry of Justice under the country's controversial Foreign Agents Law. And this month, the RFE-RL petitioned the European Court of Human Rights, requesting the court to grant interim measures, ordering the Russian Federation to refrain from enforcing the 520 administrative protocols that it has brought or threatens to bring against the media organization. And this is a really oppressive way of restricting media freedom. And John Yginsu, whom you've already met, is representing the Radio Free Europe, Radio Liberty, in their case at the European Court of Human Rights. But we have with us one of our high-level panel members, Galina Arapova, and she's going to join us, and there's going to be a discussion between herself and Professor John Yginsu. Let me just introduce Galina to you, because she is the director and senior media lawyer at Mass Media Defense Center in Russia. And she has advised on many cases addressing defamation and freedom of expression before the Russian courts, and of course, before the European Court of Human Rights. Ms. Arapova is a trustee of Article 19 and a trustee of the European Centre for Press and Media Freedom. And she has advised the Council of Europe's HELP programme. She was awarded by us at the IBA an award for an outstanding contribution by a legal practitioner to human rights back in 2016. So she's an old friend, a very committed protector of media freedom. So I'm going to hand it over to you, John, and to you, Galina, to discuss what's been happening in Russia and the great threats that are presented in this case.
Thank you very much, Baroness Kennedy, and it's an absolute pleasure to share a platform with Galina here. In fact, Galina and I have been working on systemic restrictions for nigh on 2 years now, and then this case comes up, and I will be speaking in my capacity as a member of the high-level panels, so council wig off and sort of professorial, whatever professors wear on. It is a stark example, and we do have to grapple with real cases, and this is the first case where the Foreign Agents Law has been applied to an international media organization. So I say it's a real honor to have Galina here because she's a foremost expert on systemic restrictions generally. And what better case example than the one that has been served on us in the past few weeks. Galina, I thought we could just open our conversation with a bit of background in this legislation because, you know, obviously when it was promulgated in 2011, 12, whenever it was focused on non-governmental organizations or non-commercial organizations. And love to hear from you on the background and the way in which this legislation has morphed into something else and actually become a serious concern for media freedom in the Russian Federation.
Thank you, John, and thank you, Baroness Kennedy, for such a lovely welcome to this webinar. It's a pleasure for me to join this discussion and share our experience. And I have to say that it's an unfortunate experience to be one of the foreign agents NGO which was introduced in Russia. And was labeled by foreign agent 6 years ago. And let me give you a little bit of background of legal regulation of foreign agent law in Russia. And Russia introduced, as John said, foreign agent law 9 years ago in 2012, and at that time human rights NGOs already said that they would become potential victims of that of this regulation. And lately, in a few years, one after another, human rights NGOs, Russian human rights NGOs, became foreign agents and were listed in a special registry, which is conducted by Russian Ministry of Justice, and this registry contains titles of Russian NGOs, which Russian authorities consider as foreign agents. And it's enough to have foreign funding from any source, even a donate or grant from a donor organization, any funding, and to be engaged into political activity. And political activity is quite a wide term, quite vague, and Russian legislation considers political activity as any public activity that might influence public opinion on matters of public concern. It's arranging public debate and even providing legal defense on issues of human rights. So basically, human rights organizations like the one that I lead, Mass Media Defense Center, that provides legal advice and legal defense to Russian journalists, bloggers, and media outlets. We, in a meaning of Russian legislation, conduct political activities. Even though we are not involved in any political party, we're not running elections for any post, still, according to Russian foreign agent law, this activity is political, and it's enough to get €1 as a donate from any country to become a foreign agent. So thus, majority of Russian NGOs, human rights NGOs, became foreign agents. They are labeled, and now restrictions are the following. We have to label our website and any information that we disseminate with special disclaimer saying that we are an NGO foreign agent, and plus we have to indicate all sources of funding in a special report that we have to publish on our website, which is okay, we're transparent, but we also have to provide this report every quarter of the year to the Russian Ministry of Justice. If we fail to do that, or if we provide a report with any minor mistake, that could be considered as an administrative offense. If we fail to provide audit report, which we have to pay for and conduct audit report every year, that's also a special offense, and many other things that Russian NGOs have to do with regards to the status that they have. But the problem is that it's not just the question of transparency before the governmental agencies and the public. It's a matter that the very term foreign agent, the connotation of this term is quite discriminatory. It sounds quite negative and means literally a foreign spy. And in Russian language and Russian society clearly has this negative perception when they hear that someone acts as a foreign agent. And this is actually probably the main issue, the main aim why NGOs working on foreign funding, using foreign funding for their activity, are labeled, stigmatized with this label. Now, it's important to say that we all, of course, challenged this decision and went to the European Court on Human Rights, and European Court considered two big cases of Russian NGOs, foreign agent NGOs. One case unites 61 non-governmental organizations applications, including application submitted by Mass Media Defense Center that I represent before the European Court. And a second case joins 27 organizations. Altogether, it's around 100 leading key Russian human rights NGOs working in different fields, starting from support of core human rights, such as freedom of expression, freedom of assembly, right not to be exploited or tortured, right to life, organizations working on issues of ecology, helping children with serious diseases, like all possible organizations from civil society and human rights field that you might imagine. We all joined our efforts to defend our reputation and our right to continue our activity, because any mistake that we might do with reporting, even just missing one single disclaimer on one of our publications, that might lead to administrative fine up to 5,000 euros just for one mistake. And then twice that might lead to criminal liability for director. So this is serious, and this is how it was happening for the last few years. And then that same approach was taken and to media, international media, to media which is now could be labeled as foreign media, foreign agents, with the same requirements, but even maybe higher standards, because they have to label not just the website by itself, but each and particular piece of news, which makes really no sense. And the whole disclaimer looks quite horrible, and it's just comes to a contradiction to a regular media practice. Just imagine a disclaimer that comes after heading, 24-letter long disclaimer, and size of this disclaimer has to be twice bigger than the text that follows. Like none of the normal media that follows international, well, regular standards of journalism can do that. And also the last Christmas gift which we all received from Russian authorities was the law which was passed in December last year, just 2 days before the new year. And this law now enables authorities to label as a foreign agent individuals, and even 5 individuals, 3 journalists, 1 human rights defender, and 1 activist who is just a school teacher and a feminism activist, an artist. She was also labeled as a foreign agent, and now they face same kind of problems that international media, foreign media, which is labeled with this stigma, is facing. And I know, John, that you are representing the first international media company, Radio Liberty, before the European Court on Human Rights. Can you tell us what you're doing with this challenge?
Well, Galina, thank you very much indeed. And Baroness Kennedy, I have an eye on the time, so I'll be as succinct as possible after a pretty magisterial summary and background from Galina. I mean, it's fascinating as I wish I were Russian. I wish I were a Russian speaker about 15 years ago and engaging with Russian literature. Now getting through Russian statutes, I also wish I was a Russian language speaker. But what's fascinating here is, Galina, you know, you and your organization, you've got the sword of Damocles hanging over you from 2012, 2013 onwards, but in your capacity as human rights defenders, trying to give effect to the right to freedom of expression, in particular media freedom. But then in late November 2017, that sword of Damocles, it doesn't really shift, it grows. And it's now hanging directly over any foreign media organization in Russia. 10 days after the law is widened to apply, 8 news services run by Radio Free Europe, Radio Liberty, my client, was designated straight away as foreign agents. That point, Radio Free, I'm just going to call my client RFERL because it's such a mouthful, but they eventually had to incorporate as a Russian company pursuant to the foreign agents laws. So they incorporated as an LLC. Of course, that LLC was then also designated. And until I think this week or late last week, RFERL and its news services were the only foreign media organization with a physical presence in the Russian Federation to have been designated as a foreign agent. And as Galina says, it's a pretty poisonous term, especially if you're a media organization. One of your roles is to impart information to the Russian public. And there's strong evidence to suggest, and it's evidence that's been adduced now by the UN Special Rapporteur, by the Council of Europe Commissioner. It's featured in a resolution of the European Parliament condemning the legislation. I mean, this is a very loaded term. It means an agent, i.e. a spy, acting for the benefit of an alien, of a foreign power, of an enemy country. And of course, designation isn't where it's ended. And as Galina says, media organizations that have been designated in this way have to carry, as of late last year, pursuant to an order that's come through by, promulgated, I should say, by the government communications regulator, Roskomnadzor, they now need to provide for this very, very prominent label on every single piece of news reporting, on every single bit of footage, on every single social media post. This material has been created or distributed by a foreign mass media outlet performing the functions of a foreign agent. And you know, this is a test case. The RFERL case is a test case. It's the first media organization not only being designated, but is being asked to comply with this labeling function. And those in our virtual audience probably won't be surprised that this is where RFERL said, no, we're going to comply with everything, but for us as an independent media organization to comply with this sort of labeling makes it absolutely impossible for us to operate in any meaningful way. mean, if an independent media organization with a physical presence in the country is going to have any hope of functioning in that country, it's not going to have a hope if it has to label each and every single piece of media, be tainted in this way with an express warning that this organization is a de facto enemy of the state. And as Galina said, there are very real sanctions, including criminal liability for not so complying. The first wave is administrative fines. And just to give the audiences a sense of how this legislation is being applied, since January of this year, RFERL has been subject to or has had threatened against it 520 cases pursuant to this labeling requirement, because it's said to have breached it. Every single case has been defended at first instance. RFERL has had to participate in hundreds of hearings over a period of 3 months. All first instance judgments that have been handed down so far have found the company or its director liable. Each judgment has been appealed, and each appeal that's been considered has been unsuccessful. So not a single fine has been lowered on review by a court. And at the moment, the organization is looking at a liability of just under $2.5 million. But if you take a step back, you'll understand that liability is in fact unlimited here, because for every single piece of news, a fine will follow. And if you don't comply with the fines, the end of the road is a prison sentence. As Galina said, and as Baroness Kennedy also mentioned, this case is now at the Strasbourg level. The Strasbourg court has been petitioned on an urgent basis, but it's a very stark instance of a systemic restriction on the part of a state using its regulatory powers to suffocate free media. And no doubt many of you will continue to follow this case, but as a panel, we will be looking at these sorts of restrictions. It won't just be foreign agent laws. We'll be looking at accreditation, licensing, tax fines, prohibitions on foreign ownership. Some of these laws may be pursuing perfectly legitimate aims. The case that we've just talked about, slightly questionable what the legitimate aim is, but really we're looking at the abuse on the power on the part of the state of its powers, of its regulatory powers. And I look forward to working with Galina and my colleagues on the panel on this important work.
Well, thank you both, because you're flagging up one of the things that is increasingly happening in countries where law is being introduced and it's presented as being protective of national security, and in fact it's a means by which you have a crushing of free speech and freedom of expression, and a closing down of opportunities for people to know what is really going on. That's the whole purpose of the media speaking truth to power. Now, please, any of you who've got any questions, do put them into the Q&A, and I will feed them towards our speakers, Jan and Galina. I've got a question though, while we're waiting for people to come up with some more. I wanted to know, Jan, whether you're taking this case now on behalf of your clients. Have you seen, has Russia, the Federation, presented a rationale for why this is being done, why this is necessary in this particular case?
Not yet, not in the context of this particular case. There've certainly been statements at the media level, and there've also been statements in response to European Parliament resolutions and so on and so forth. Arguments around, similar looking legislation in other countries, including democracies such as the United States. Of course, on a very close review, Baroness Kennedy, you'll appreciate that the laws are being applied and the laws themselves look very, very different. But politically, it's been, and I'll defer to Galina as well, it's the position has been, there are other foreign agent laws generally, and this is just, you know, the Russian Federation using its sovereign powers to protect itself.
And I would just add to what John said, that we have seen position of Russian government in their observations on the foreign agent case with regards to NGOs. And the main message is that any foreign funding coming to support NGOs in the country, or any information disseminated for the Russian public reading in Russian language, that might be the instrument taken by foreign countries for other countries that are trying to interfere with internal Russian affairs by spreading information and criticizing Russian government for what they're doing. And that's actually what they believe Russia has to stop, this foreign pressure and interference with internal affairs. That's the issue, that's the aim of the foreign agent law, as Russian government says before the European Court in the previous case. And I think that similar position will be taken in the case of Radio Liberty, because that's the message that we hear from Russian authorities when they explain why they label foreign media with the label of foreign agent, and why they're pushing them to put this disclaimer, like a warning for reader, that just be aware that this message is disseminated by someone who doesn't like Russia, who is using American or British or someone else's money to brainwash Russian citizens with some kind of like unfriendly information. That's kind of message behind it, unfortunately. And it's clear interference with the right to freedom of expression and the right to freedom of assembly. And Russian NGOs have raised also these two issues of violation of these two fundamental rights in conjunction with Article 14, discrimination, and Article 18. And let's see how it goes.
Baroness Kennedy, I'd just say one very short comment in response is, I mean, this is not a Russia problem. This is a Council of Europe problem, because it is quite clear that some other states will be following this case very carefully, or by reference to legislation that's being threatened. I won't give names at this point, and this is why, as a panel, we have been, even before this case, looking at the issue much more broadly, and we will continue to be looking at it much more broadly.
Yes, I mean, I just want to say that you know, we are seeing it in places, and we know that this will be emulated by others, and certainly probably in the region, but also, and we only have to look at Hong Kong just now, where the national security law is now being invoked against someone who's just been convicted, Jimmy Lai, who is the owner of a newspaper and other media, and has been imprisoned, and he's facing further charges around that national security law, and it relates to his interaction with what they say is foreign agents. So I want to draw this webinar to a close. It has been really stimulating to, as I hope you will all agree, to hear from distinguished lawyers who've been working on this panel on this whole set of challenges that is facing our world just now around the news, the importance of having good information, because without good information, we can't know what is being done in our name. We can't know what is happening to other citizens in our nations. We cannot protect the rule of law and human rights. And so media freedom is one of those fundamentals. And so it's the pillar that has to be protected if we want to protect the other rights which people need in their lives. So I want to thank all of my speakers. It was wonderful having you with us today. And I want to thank all of you for joining us, those who are listening in and watching virtually. And I want to thank UNESCO for the great work it's doing on media freedom. And let's encourage more nations to join the coalition to protect media and journalists. Thank you. Thank you all.